In the last video, we revealed how the Victorian Legal Services Board and its appointed external manager, Mr Rapke, collaborated with the firm's opponents, disclosing confidential files and assisting in the humiliation of their clients, all caught on camera. In this video, we go deeper, exposing how Mr Rapke and the VLSB may have exploited the Public Purpose Fund, operating with little to no oversight or accountability. Let's go back to August 22, 2022, the day Mr Rapke came to take over the office. While looking around, he found one of Lulu's old business cards that said she was a director.
Sorry. You might like to have one of those as a memento. You're a director. That's interesting, isn't it? For someone
Why don't you read documents?
Another director, and you're a director too. That's all right.
Mr Rapke was still bitter that Lulu didn't open the door when they arrived, even though she clearly told them she wasn't an authorized person. Here's the background. Lulu was the firm's director from July 2021 to May 2022. So when Mr. Rapke arrived to take over, she was no longer in that role. Yet he still felt the need to defend his pride over it.
Lulu?
Sorry, I'm taking some medication.
Here's a card of yours just in case you forget you were a director, okay?
Can you check the... Please do some homework.
Did Mr. Rapke do his homework before showing up? Well, the invoice he issued suggests he started background research as early as August 15, 2022. This is 1 week before he came to the office. On August 17th, he ran 2 InfoTrack search on People Shop Proprietary Limited. From August 16 to August 31, 2022, the firm was billed a staggering $92,035.37 by Mr. Rapke. The hours? Completely arbitrary. 50 hours for a partner, that is Mr. Rapke, at $475 an hour, 73 hours for a solicitor at $280 an hour, and special counsel, Kylie Hall, billed for 61.9 hours at $425 an hour. You'd think there'd be an itemized breakdown of the bill, right? But no. Scroll down, and there's nothing. Just a list of reimbursements. That's it. Let's be fair. Maybe Mr. Rapke simply forgot who the director was at the time when he took over the firm. But for a firm charging $92,000 for just 2 weeks of work, including a whole week of dedicated research, Mr. Rapke and his team should have known that Maria and Shivish were the firm's clients. The following month, we received yet another invoice, this time for $48,851.05. It included a few taxi bills, 5 hours billed by Mr. Rapke, over 55 hours from 2 paralegals, and 61 hours from special counsel Kylie Hall. Still, no real explanation of what any of them had actually done for an entire month. Third bill that came 4 weeks later, same, no explanation on any of the charges whatsoever. So, is it actually legitimate for Mr. Rapke to invoice the firm this amount? Let's take a look at the Legal Services Board's appointment letter to find out. In this cover letter, Mr. Howard Bowles, the VLSB's Manager of Intervention and Enforcement, writes, "Under Section 365 of the Uniform Law, the fees, costs, and expenses of the manager are payable in accordance with the Legal Profession Uniform General Rules 2015 and are payable by and recoverable from the law practice. If you have any questions about this matter, please contact the manager on 0419-376-525 or Joanne Jenkins, etc." The instrument of appointment of manager, signed by the Director of Investigations, Mr. Matthew Anstey, includes a statement at paragraph 6, where he says, "The fees payable by way of remuneration to the manager for performing his functions shall be at the hourly rate of $475 plus GST." And paragraph 8, "To the extent that the fees, costs, and expenses referred to in paragraph 7 of this instrument are not paid by the law practice, they are payable from the Public Purpose Fund, in accordance with Section 365 of the Uniform Law, and are recoverable from the law practice." According to this instrument, only Mr. Rapke is authorized to charge $475 per hour for performing his duties as the appointed manager of the firm. So how, and since when, does that authorization extend to bringing in his colleagues and charging $425, $280, $215 an hour and so on for their time? Over the next 4 months, another 5 invoices came in, adding up to more than $30,000. And what exactly did they do for the firm's clients? Nothing good, only damage. First, Mr. Rapke filed notices of intention to cease acting as solicitor across multiple courts, then abandoned the cases right before critical hearings. He withheld both physical and electronic files, leading to serious default judgments against his own clients. If the Legal Services Board's goal was to inflict maximum damage, then for $200,000, Mr. Rapke certainly delivered. We're not the only ones. Since April 2025, Shivesh and Peter were contacted by Mr. Glenn Thexton, who introduced them to other lawyers and individuals with serious concerns about how the Victorian Legal Services Board was acting. Among them were Mr. Thexton himself and Mr. Thomas Flitner. Both shared stories that were shockingly similar to ours. Both reported that, under the management of Nick Curran, another external manager appointed by the VLSB, their firms were subjected to aggressive and questionable billing practices that ultimately left their businesses dismantled and destroyed. In 2020, the Victorian Legal Services Board suspended Glenn Thexton's practicing certificate and appointed Nick Curran from Thomson Geer as external manager of his law firm. Later that year, Mr. Thexton filed a case in the Supreme Court Costs Court to challenge hundreds of thousands of dollars in invoices issued by Thomson Geer. He was never consulted on the charges or allowed to review them. But soon after filing the case, Thomson Geer offered to settle, asking him to drop it and sign a release to prevent any future claims. They also confirmed that the invoices had now been reissued to the VLSB and that the VLSB had paid them from the Public Purpose Fund. Instead of defending the charges in court, they redirected the cost to the Public Purpose Fund and tried to make the dispute quietly disappear. A few months later, Glenn Thexton's firm, Thexton Lawyers, received a tax invoice from the Victorian Legal Services Board. In response, Mr. Thexton filed applications for costs assessment in the Supreme Court Costs Court, formally challenging the validity, reasonableness, and legal basis of the charges incurred under the external management of his firm. In his submissions to the Costs Court, Mr. Thexton set out that within just 6 months, Thomson Geer had billed his firm a staggering $607,825. The submission states an average of $101,304 per month, or about $16,930 per week. And this wasn't just Curran. The invoices included fees for an entire team. Jody Blows, Michelle Licciardopoulos, Rachel Van Gemert, Laura Hook, Mark Brannigan, and others, both legal and paralegal. What's worse, Thexton wasn't given any real opportunity to dispute the bills. As stated in the submissions, Mr. Curran did not cause Thexton Lawyers to pay Thomson Geer's bills, even though he was Thexton Lawyers' manager, and Mr. Thexton had no authority to cause Thexton Lawyers to pay them, and Thomson Geer then reissued each bill to the Victorian Legal Services Board a month or two after they were originally dated, but without withdrawing the original bills. Then came the most outrageous part. Curran and his team charged Thexton's firm for preparing affidavits and giving evidence in court against him. The submission says, "It is apparent from the bills that Thomson Geer charged Thexton Lawyers for the work and its staff members giving evidence in those proceedings, the costs of which, including witness expenses, are the subject of an indemnity costs order made in favor of the Victorian Legal Services Board against Mr. Thexton. It seems very likely, therefore, that the Victorian Legal Services Board will seek these costs twice, once from Mr. Thexton and once from Thexton Lawyers, a scandalous situation." And the submission doesn't hold back. It declares, something has obviously gone awfully awry here. It then lays out a series of failures and questionable practices, not just poor oversight, but systemic mismanagement. The respondents seem to have acted on the erroneous assumption that Thomson Geer, rather than Nick Curran, had been appointed as manager, such that lawyers and non-lawyers alike are free to manage Thexton Lawyers so long as they were notionally supervised by Nick Curran or one of his partners. In plain terms, it alleges that lawyers and non-lawyers alike were left to run Thexton's firm under Thomson Geer's name without legal authority, while Curran nominally oversaw it. The bills also included costs for work done in Queensland and Western Australia, even though the submission points out those services were outside the scope of the Victorian appointment. It says, Thomson Geer has invoiced the Victorian Legal Services Board for work, done pursuant to external interventions on behalf of other jurisdictions' regulators, which claims are properly made to those other regulators, and the Victorian Legal Services Board now seeks to require Thexton Lawyers to pay those claims to it. The regulator that should have been watching closely did absolutely nothing. The submission points the finger squarely at the Victorian Legal Services Board, saying it failed to act even when it knew something was seriously wrong. The submission says, despite all of the above, the LSB, which might be thought uniquely placed to appreciate these issues, has for reasons which are unexplained, apparently not taken any issue with what has happened. And despite knowing of the Thexton lawyers' dissatisfaction with the Thomson-Gears claims, has not exercised its rights under S. 103-2 of the Uniform General Rules to seek taxation or assessment, perhaps because no account has in fact been given by Mr. Curran as opposed to the Thomson-Gear. This submission was prepared by Barrister Stephen Warren, acting for Mr. Thexton. In it, he forcefully took aim at the Legal Services Board over an invoice they issued on May 28, 2021. One that totaled more than $600,000. Just weeks later, on June 15, 2021, in a related Supreme Court case, Glenn Thexton had the chance to cross-examine a staff member from the Legal Services Commissioner's office. What you're about to hear is a voice recreation using AI based on the official transcript. It reveals how a payment exceeding $500,000 was approved.
Thank you, Your Honor. Thank you, Ms. Small. Just by way of further background, Ms. Small, can you explain to the court in terms of your role at the Legal Services Board, am I correct to say that you were working for the Legal Services Board?
I'm employed by the PLI. I was employed by the Commissioner. The Commissioner employs all staff of the Legal Services Board and the Legal Services Commission. Commissioner. But most of my work was performed for the Legal Services Board. So I was the Assistant Manager of the Intervention and Enforcement Team, and the role of the Intervention and Enforcement Team in these circumstances is to ask the Board to appoint a manager to a practice, and then once that manager is appointed, then the team oversees, liaises with the manager about the progress of that management. As the assistant manager, that was primarily my role with the assistance of another staff member and under the supervision of my manager.
And so, Ms. Small, can you tell the court what the total of the balance of the monies that were paid by Legal Services Board to Thomson-Gear?
The total of the balance? What do you mean?
How much was paid?
I could not give you. I think it was certainly over $400,000. I'm not sure whether it was $500,000. I can't recall the total figure.
And you haven't seen any reissued invoices, I just want to clarify that.
I believe I have along the way, but I can't recall seeing that one specifically.
Okay. Now, in relation to the appointment of a manager in your experience, in your role with the Legal Services Board, is it common that simply invoices, be it the reissued invoices, are simply paid without challenge or contest?
The finance team sends the invoice to the manager of the Intervention and Enforcement Team, and he considers it. He may ask team members for comment on whether this seems proportionate to the work done, and if so, he will approve or send it to the next level for approval of payment.
All right, and that was done in the case of Thexton Lawyers Pty Limited, correct?
From time to time the manager of the Intervention and Enforcement Team would ask Ms. Pickering or I if, this looks proportionate, and we would respond. We potentially scan the invoices to ensure that everything was reflective of the work we knew was proceeding. That would not happen necessarily every time, but it would certainly happen from time to time.
Okay, so that was your job and you were doing your job. In relation, Ms. Small, to the invoices in undertaking that exercise, you would pick out certain line items and say, well, that's not proportionate, we're prepared to pay you this much, but we won't pay you the full amount of the invoice. That's the usual course?
It would tend to be more kind of bigger picture things. I wouldn't know how many hours a particular matter aspect had taken, but it was something that appeared to be unnecessary for a manager to be pursuing or doing, or if we thought they could do it in a more efficient way, we would raise that.
The Victorian Legal Services Board, a regulator entrusted with oversight, yet in court, its own officer admits invoices for hundreds of thousands of dollars were paid with little scrutiny. Thomson-Gear received over $600,000 for Thexton Lawyers management, maybe more, and those bills. Reviewed only from time to time, often without questioning line items or costs. We'd scan them, said Ms. Small. Sometimes, not always. Thomas Flittner faced the same problem. Nick Curran, appointed by the Legal Services Board, billed over $200,000 without any breakdown or justification. Instead of managing the firm, he told clients to go elsewhere, offering no help or file transfers. The firm fell into chaos, clients were abandoned, and a 20-year practice collapsed. Appointed to act in the public interest, Curran protected nothing, except his own profit. Let's take a closer look. Just from our firm, People Shop, Mr. Rapke was paid nearly $200,000 from the Public Purpose Fund. Nick Curran received over $600,000 for managing Thexton Lawyers, and more than $200,000 connected to Mr. Flittner's firm. Altogether, $1 million was drawn from a fund meant to serve the public. The issue? Those bills were challenged. These invoices were disputed, questioned, and in several cases appeared to lack any clear legal or factual basis. Yet the Victorian Legal Services Board approved them without hesitation. What Nick Curran did was calculated. He got the VLSB to pay him first. Then the board turned around and threatened to recover the cost from the firms. And when the lawyers tried to object, they may be told, "You're not the client. You have no standing to challenge the charges." Wait, this is actually exactly what he is saying. Maybe that's what they really want. Bills paid from the public purpose fund, but no way for anyone to challenge them. No questions, no objections, just silence. So what is the public purpose fund? It's a statutory fund in Victoria, meant to support the regulation of the legal profession and improve access to justice. It's funded largely from interest earned on client trust accounts, and it's supposed to go toward things like legal aid, community legal services, law reform, and judicial education, not to bankroll inflated invoices from private contractors. What most people don't realize is that Victoria Legal Aid isn't just funded by government grants. It also relies on this very fund. Yet when someone applies for legal aid, the process is long and invasive. Applicants must submit detailed records, bank statements, income, expenses, even housing costs, just to be considered. And still, many are turned away. Not because they aren't in need, but because the system is set up to make access difficult and selective. Meanwhile, the same public purpose fund is used by the Legal Services Board to pay private law firms it appoints as external managers, often in secretive takeovers of other firms. Those payments? No means test, no scrutiny, no public interest threshold, just invoices paid often in the hundreds of thousands without question. Remember what Ms. Small says in court?
How much was paid?
It was certainly over $400,000. I'm not sure whether it was $500,000. I can't recall the total figure.
Is it common that simply invoices, be it the reissued invoices, are simply paid without challenge or contest?
We potentially scan the invoices to ensure that everything was reflective of the work we knew was proceeding. That would not happen necessarily every time, but it would certainly happen from time to time.
According to the VLSB's 2024 annual report, at 30th of June 2024, the total value of the Public Purpose Fund was $3.2 billion. Yet despite the size of the fund, there is practically no supervision or accountability over how the Legal Services Board uses it. The Victorian Legal Services Board decides how to allocate money from Public Purpose Fund based on its own internal plans and policies. But the process is entirely opaque. There's no independent oversight, no public audit, and no transparency on how the money is actually spent. While the Attorney General must approve the payments under Section 144 of the Legal Profession Uniform Law Application Act, that approval appears purely administrative. There's no requirement to scrutinize whether the amounts, sometimes hundreds of thousands of dollars for vague or inflated services, are fair, reasonable, or even legitimate. How could the Attorney General possibly verify invoices like those issued to Peopleshop, Flitner, or Thexton when even they weren't allowed to properly examine the bills? With no real accountability and no external checks, the system leaves public funds wide open to misuse, while those who challenge it are threatened, silenced, or bankrupted.